And we actually did have an email question come in during the break, Brian. And if we could put the question up on the screen here, we'll get it going if we do have it. If we don't, okay. I'm gonna go ahead and we've got it, here we go. So my cousin was killed when his motorcycle hit an SUV. It's been suggested that my cousin was speeding, but the driver definitely turned in front of him. If they can somehow prove that my cousin was over the speed limit, does that mean his family has no claim against the driver?
That's an easy answer. Of course, there is still a claim against the driver. Up until, I would say, March 25th, Florida was what we call a pure comparative fault state. So even in the event that somebody was speeding, a jury has to weigh that fact if there's evidence out there. You are not allowed to just testify that you saw a car going fast and it looks like it was speeding. That's not permissible evidence that a jury would actually ever get to see. You gotta, what we do is we do downloads of vehicles that tells you how fast the vehicle is actually going. But in Florida, prior to March 25th, 2023, we were a pure comparative fault state. So let's say your cousin, unfortunately, who passed was speeding, say 10 miles over the speed limit. Then at that point in time, the jury would have to weigh that versus the driver who failed to yield, who turned in front, who's the main contributing cause. On those cases, I would say there's a possibility that someone is speeding, but you still have a duty to yield to oncoming traffic.
Well, Brian, you know, we're talking about this new law that's been passed, that's been recently signed, and there's absolutely no way that the average person in the public understands what they are facing now that our state legislature has passed, actually to the detriment of everybody who owns a vehicle or even on the roadways or going anywhere to where there could be a liability issue.
Correct.
And so let's kind of explain this real simple if we can. Pure comparative versus, I guess, a modified contributory state. So pure comparative is you, out of 100% of something, if you were 20% responsible for the accident and you get awarded X amount of dollars at a jury trial, it's going to be reduced by the percentage of fault of the 20% that you were at fault. So you would get 80% of the verdict at trial. And this is very simple math. In today's law, that was just recently signed, we totally abandoned that because apparently that didn't make any sense. And we've had that in place for many, many, many years in the state of Florida. And we're all scratching our head about this when this law was signed, that now we have what's called a modified contributory state, I guess, is what we have. And if you are deemed to be more than 51 or more than 50% responsible for the accident, you get zero.
Yeah, so in this
situation here.
In this situation, there is a chance that, a jury thinks that your cousin was 51, 52, 53%, and that they determined, the family's entitled to $10 million. On our old law, before it changed in March of 2023, there would still be a multi-million-dollar verdict to help compensate the family, which is kind of fair if there is fault.
Right.
But now under the new law, if a jury determined, speeding or wasn't wearing a helmet contributed to this, then if it's more than 50%, the family is not entitled to anything for their loss. And again, we are not really sure why the legislature did what it did, but that's one of the reasons that if someone is injured, hurt, killed, whatever it is, you need to have a lawyer who actually practices in that line of work so they can be up to date with how the law is changing, every year.
Well, that's why we specialize in what we do, Brian. That's why we advertise what we do so people know that we're there to help them in situations and be up to speed on the law, because under the old statutes, you would get what was rightfully owed to you. Under this new law, and I can't harp on it enough, it's awful. It's devastating. I mean, it's just idiotic that someone, if they just have an unfortunate jury pool that says, hey, look, you should have been wearing your helmet, even though you could not wear your helmet riding a motorcycle. If you'd have worn your helmet, you wouldn't have suffered as bad of injuries as you had, and you get zero now.
And one of the bigger things is we're talking about jury trials. We do try cases, but those are few and far between. How it really will affect everything now is if an insurance company who insures the person who killed somebody who wasn't wearing a helmet, they might take the position that, hey, we're not offering you anything. We think they are more than 50% at fault. So now the family and everybody can't negotiate with the insurance company. We can't negotiate with the insurance company, and then we have to go try the case.
Well, there's nothing wrong with that because, I mean, we're not afraid to try cases. We try cases every year. But I think the point that you're trying to make is it's just going to delay even further, and getting to a jury trial is going to take, I mean, it takes a long time to get your case to a jury and get it in front of a judge and get a jury selected. You just don't go down to the courthouse and say, okay, well, I'm going to do a jury trial next week, because you have so many that are before you.
No, and it also, especially in this situation where someone was killed, most of the time, a settlement doesn't bring anybody back, a jury verdict doesn't bring anybody back, but it brings families closure, and this law can potentially just delay that and drag it out. And again, there's no real benefit to it except to the insurance companies who lobbied and supported it.
The insurance companies won, and don't let that go unnoticed. We have to say that.
In this legislative session, they won.
They won in this legislative session, but they will, will thank the Lord. There's good people like us out there helping people that need the help.